Hi everyone, and thank you for joining us today. My name is Clodagh Daly and I'm Manager of Community Law and Mediation Centre for Environmental Justice. In today's webinar, we will take a deep dive into our environmental rights at the local level in Ireland. If you have a question, please put it into the Q&A box at the bottom of the screen. And if you see a question similar to one you'd like to ask, please like that question with the thumbs up icon, and we'll have a Q&A discussion at the end. Just to briefly provide a little background about our work. Community Law and Mediation was set up in 1975 as part of the campaign for civil legal aid in Ireland. Today, we assist more than 4,000 people each year through the provision of free legal, education and mediation services. We also campaign for law reform and for the safeguarding of rights already enshrined in law. And we work in areas of law which are not catered for by the Legal Aid Board. This includes areas like housing, employment, equality, social welfare, debt, and access to services, such as healthcare and education. In February of 2021, we expanded our work into the area of environmental justice by setting up Ireland's first ever Centre for Environmental Justice. And environmental justice isn't a concept that is very well known, but essentially it ensures that people experiencing poverty, inequality, or social exclusion are not disproportionately impacted by climate change or by other environmental harms. And it also ensures that the state's response to environmental challenges is both inclusive and fair. Through our free legal advice clinics, we regularly assist people who have been disproportionately affected by issues linked to the environment and poor planning because of where they live and where they can afford to live. And these issues include a lack of green space, threat of flooding, poor air or water quality, noise pollution, or illegal dumping, being just some of the examples we've seen. And the voices of these communities are rarely heard in policy responses to planning or environmental decision-making. And in addition, it's become clear that information has not been actively provided to communities as to how such issues can be addressed. So environmental complaints are critically important in this regard. They inform public authorities about where and when the law might have been broken and by whom. Environmental complaints contribute to ensuring compliance with Ireland's environmental obligations and improves environmental lawmaking as a whole. And finally, environmental complaints serve the interests of society as a whole. In protecting the support systems we rely on, we protect our community's right to breathe clean air and drink clean water, as well as protecting the rights of future generations. And in addition to environmental complaints, a key principle of environmental law is that environmental decisions are best handled with the participation of those concerned. This principle is embodied in the Aarhus Convention, which has been part of the EU legal order since 2005 and was ratified by Ireland in 2012. Environmental democracy and oversight have never been as important as we grapple with an ever-increasing climate crisis. And participation in environmental and planning decision-making is critically important. The government cannot reach environmental protection goals alone. It needs the support and guidance from the public. And increased public participation can increase the legitimacy of decisions and help ensure that policymakers have valuable local knowledge. At Community Law and Mediation, we believe that policymakers should invest resources in the capacity building needed to facilitate equitable and inclusive public participation. We also believe that the government at all levels should provide enhanced transparency as to how public participation informs policy and planning to improve the legitimacy of public participation processes. Public participation will not improve democratic practice if it is not inclusive. And likewise, public input does not improve the quality of decision-making if the right people aren't in the room, or if decision makers don't actually take that information into account. It's also worth noting that public participation is not limited to formal participation mechanisms. Participation can include both invited and created spaces. So invited spaces are participation opportunities such as public consultations, where the decision-making authorities invite the public to provide input. But citizens themselves also create spaces for engagement through mobilization, where a really wide range of tactics can be used to influence policy. And both of these methods are highly valuable. So we're delighted today to welcome our two expert speakers, Michael Kinsley and Phoebe Duvall. Michael Kinsley is practicing barrister at the Law Library since 2009, with a broad-based civil practice, including civil litigation and judicial review. He holds a postgraduate qualification in environmental and planning law from King's Inns, Dublin. And Phoebe Duvall, whose background is in environmental policy, is the Planning and Environmental Policy Officer with An Taisce, one of Ireland's oldest and largest environmental and heritage organisations. An Taisce have a statutory role as a prescribed body in the Irish planning system, and as such, Phoebe reviews hundreds of planning applications every year, assessing the potential environmental impacts of developments, as well as environmental legal compliance. And she also works on a wide range of environmental and planning policy issues, including the application of EU law in Ireland and access to justice. So I'm going to hand over to yourself, Michael.
Okay, good morning, everybody. I'm going to try and share my screen, which I hope will work, and it should be sharing now. Hope it is. Yep.
Perfect. Yeah.
Great. Okay. So what I'm going to talk to you this morning about is just some of the, I suppose, basic provisions for environmental protection in Irish law, and the kind of things you would see in your own environment, your own locality, your own place, and how you might identify the obligations of actors and whether or not they've been breached, and how you might go about raising a complaint or who has responsibility for enforcement. And the things I'm going to look at are things I've been asked to look at are essentially air pollution, noise pollution, water pollution, and then the whole regulatory system around waste in Ireland. And I'm going to have I suppose, you could do a good few hours on each of those topics, but I'm going to have a sort of a whistle-stop tour through the basics of all of them. So in the context of air pollution, the statutory framework or the major statutory intervention in Ireland is the Air Pollution Act 1987. Some of the things that does is it mandates local authorities to take measures necessary to prevent or limit air pollution in their functional area. So it creates this broad, one of the things it does is it creates this broad obligation on local authorities to regulate the occurrence of air pollution and prevent, in certain circumstances, the occurrence of air pollution within their functional area. It creates the ability to obtain a pollution license, which is a necessity when certain actors are involved, mostly industrial actors. It requires companies and commercial actors to use measures to prevent or limit pollution. The Act is essentially a creature of our European obligations, and we'll talk in a minute about some of the wider frameworks in terms of European obligation. But it does envisage some pollution happening. That should be said. It doesn't envisage that no air pollution will ever happen, but it makes an attempt to limit that, to prevent it, and to create an obligation on actors, particularly industrial actors, to limit or prevent pollution where that can be done, particularly using technological methods available to them. So a local authority is empowered under Section 26 to issue a notice specifying corrective measures that should be taken by a polluter. And those have to be complied with, and there's enforcement mechanisms available to the local authority where that is done. One of the things that you'll see running through all of the areas that I'm going to talk about today is that the local authority and or the EPA have a regulatory function, and often that regulatory function will consist of the issuing of notices, the issuing of essentially compliance requests by the relevant authority, and an enforcement mechanism following on non-compliance. And it's not the only mechanism available, but it does feature as one avenue in a lot of these areas. A local authority is empowered to declare a special control area. They've done the most common example is the ban on smoky fuels. That's been extended and updated in recent years. It's quite topical at the moment because there's a lot of talk around the extension of restrictions on smoky fuels, in particular peat, around the country. But there are quite extensive, particularly in urban areas, Dublin and other urban centres, there are fairly extensive restrictions already on the sale and burning of certain solid fuels, smoky fuels, as they're called colloquially. And those obligations are on sellers and householders. And it's an interesting regulatory regime in that it's quite exacting. It comes from the legislation, but it also comes from regulations thereunder. And it's quite exacting on the sellers and those who provide for sale fuels, particularly coal, must comply with very kind of stringent obligations in terms of registration and compliance in terms of the smoking value of those fuels. Local authorities enforce penalties for infringement. The penalties in respect of breaches of the legislation are a Class A fine, which is the new terminology for a fine of up to €5,000 on summary conviction, or 6 months imprisonment. Also, you can be issued with what's called a fixed penalty notice. Again, something you'll see in common with all of these. And if you pay that, you get away essentially with a lesser fine. But if you don't pay that, you can be prosecuted and the higher fines apply. There are certain specific regimes that I've just put in. Now, there are a number of them, and I don't have them all here, but I just thought some of them might be useful to you to be aware of, more common ones. Specific ones in respect of installation activities and organic solvents that has specific regulation applying to it. The local authority in that instance issue a certificate of compliance. Then when you're dealing with paints, varnishes, vehicle refinishing products and activities, there's a regulation from 2012 that which concerns the air pollution potential of that activity. Person carrying out vehicle refinishing must obtain a certificate of compliance from a local authority. So that's important to know if you have one of those in your locality and you're concerned about whether or not it's operating in a compliant manner. There is a statutory regime with which it must comply, and it must do that by getting a certificate of compliance from the local authority. There is civil liability. So those are the enforcement mechanisms, I suppose, for the local authority. What I've been asked to comment on and what I just want to mention as well is that there are ways in which the individual can intervene in these types of breaches. Now, it should be said that, court proceedings and enforcement proceedings in the court, civil proceedings, are expensive, they're time consuming, and they can be stressful, quite frankly. And so I suppose it will invariably be the case that a citizen will prefer that the local authority or the EPA, depending on who has responsibility, and you'll see as I go through the slides that varies depending on the area. A citizen will probably, in most cases, prefer to have that authority take the enforcement action where there is a breach. But there are circumstances in which that hasn't happened, is not happening, or the local authority has a different view on the level of compliance. So there are avenues available to the individual citizen, and I'll mention those as we go along. In the context of air pollution, Section 28B of the 1987 Act, which has been inserted after 1987, allows for civil liability where damage has been caused by the air pollution. You would have to demonstrate the damage that has been caused. You'd have to have proof of that up to the civil standard. So that wouldn't always be the case. I apologize. I realize now looking at the slides that I put too much into that slide, and the writing is very small, but if you can forgive me for that, I'd say the last point, the last bubble there says that local authorities can take urgent measures, so they can seek the court to intervene where there is ongoing, existing, very serious breach of the Air Pollution Act. They can seek what is called in other contexts an injunction. A person or local authority can apply to the High Court to prohibit or restrict emissions where they're occurring outside of the confines of the Act, or outside of what is allowable within the Act. And a person can, under Section 28A of the 1987 Act, seek the intervention of the Circuit Court or the District Court in order to limit air pollution. And the jurisdiction there depends on the cost of compliance, essentially, which isn't always easy to measure from the point of view of the citizen deciding what avenue to take. But what I will say to you is that if you pick the wrong court, there is a mechanism to send you to the right court. So that mechanism is available to the individual. You'll see also that there are various European standards, the most comprehensive of which is the CAF directive, which places obligations on the state, on local authorities carrying out that function, and on the EPA in terms of managing air pollution, having plans in place to tackle air pollution, ensuring compliance with good air pollution standards, air quality standards, and disseminating information. And those are rights which are enforceable against the state. Those are obligations which are enforceable against the state, which I'll talk about maybe at the end. But just to let you know that I suppose, it sets out the regulatory framework of all of that. The next thing to talk about is noise pollution. And noise pollution is regulated primarily by the Environmental Protection Agency Act 1992 as amended, and it's amended quite significantly from 1992 onwards. The Environmental Protection Agency, or the local authority, which is what LA stands for in that slide, takes steps to ensure compliance with a notice to control noise. So you'll see there again where there is noise pollution taking place, and noise pollution is defined under the Act, but where that is taking place, a notice can issue, and the notice has to be complied with. There is a mechanism whereby the alleged polluter is entitled to engage with the authority which is issuing that notice, but once that's done and the notice is affirmed, there must be compliance with it. There's regulations setting out in more detail requirements around noise and noise pollution. And I suppose maybe of most interest, and so the complaints can be made to the EPA or the local authority. And I have a link for the EPA in my last slide. Depending on what exactly you're complaining about, they have different jurisdictions and different responsibilities. But if you go to one and you should be with the other, you can be fairly certain they'll send you in the right direction. In particular, the EPA has a very useful page, which I'll put up at the end, which essentially sends you to, delineates where you should be. And if you're in the EPA in circumstances where you should be in the local authority, they'll send you there. So I wouldn't get bogged down in that. But there is a mechanism under the 1992 Act, which allows an aggrieved person to go to the district court under section 108, where any noise which is so loud, so continuous, so repeated, of such duration or pitch, or occurring at such times as to give reasonable cause for annoyance to a person in any premises in the neighbourhood, or to a person lawfully using any public place, a local authority, the agency, or any such person may complain to the district court, and the court may order the person or body making or causing or responsible for the noise to take the measures necessary to reduce the noise to a specified level, or to take specified measures for the prevention or limitation of the noise, and the person or body concerned shall comply with such order. So a very long definition, one that, you know, if it were contested, would take a long time to go through in terms of proceedings and evidence and all the rest of it. But that mechanism is available to a person, also available to the relevant authorities, but is available to a person also. Noise action plans is a requirement of European legislation, as given effect to by the 2018 regulations in Ireland, and those have to be in place, and that's an enforceable requirement in terms of the relevant authority. Water pollution. I suppose water pollution in Ireland, the regulation of water services in Ireland, it can be split up maybe into two areas. There's the provision of services in terms of Irish Water and the 2007 Act, which I'll talk about in the next slide. And also there is overarching European framework around water pollution, water quality, and water courses. The Water Framework Directive, which you'll see cited there, provides, and the 2003 regulations as amended, which implemented them in Ireland, which implements that obligation in Ireland. It applies to rivers, lakes, groundwater, and transitional coastal waters, and sets out environmental standards which must be maintained in respect of water courses, etc. One of the things it does, and one of the most impactful interventions, is it creates this requirement for river basin management plans, which must be prepared and reviewed every 6 years. And those are very comprehensive, and there's can be public participation in those, and it's an enforceable requirement in any event. The Water Policy Advisory Committee was created by the 2014 regulations. There's a huge amount of regulation in this area. I'm not suggesting that you go and try and memorize or even be overly concerned with the specific regulation, and I think a much more useful thing from today's talk is the general principles. But in any event, it's useful to know the regulatory framework. And the Water Services Act 2007, I suppose, is the overarching domestic piece of legislation, impacted, of course, by European requirements in Ireland. And it is the piece of legislation which, although supplemented and amended in particular in 2013, is the piece of legislation that deals with water conservation in Ireland. It actually was the piece of legislation that first mainly contemplated water charges and all that controversy. The subsequent pieces of legislation have transferred a lot of the powers in respect of water and a lot of the obligations in respect of water to Irish Water from local authorities, in particular in Act of 2013. There are powers in any event for the relevant authority to give effect to conservation of water, something that will become much more important in the years to come, because summers are getting warmer, water is getting scarcer. And so water conservation is going to be a feature of our lives into the future. And there is a regulatory framework already there. Water restrictions under the 2008 regulations can be put in place. And it's an offence not to comply with those. And it'll be interesting into the future to see the extent to which, number one, the state actually goes about enforcing breaches of hose pipe bans, to put it very at its most basic level, but maybe, I suppose, more egregious corporate breaches of water restrictions, and the extent to which individuals will consider breaches of water restrictions to be antisocial, because when water scarcity becomes a real visible thing, I think the extent to which one's neighbours will tolerate one watering their large garden, I think, will become much more limited. And so that mechanism is there, and I think we'll see more of it in the future. Water pollution in Ireland is governed by the Local Government Water Pollution Act 1977, and there are a number of them up to 1990. A party can obtain an effluent discharge licence. They have to be obtained if you want to discharge wastewater into a watercourse. Irish Water or the local authority, depending on the circumstances of that. But if that's been done without a license, then it's an offence, and it's a matter that can be enforced against. I realise I'm spending a bit too much time, so I'm going to maybe breeze through this one. It's waste, and waste pollution, obviously a massive area. You can talk about it all day. The Waste Management Act 1996 is the framework legislation. It provides the framework around waste management, licenses, permits to handle waste, permits to collect waste, permits to store waste and process it. All of those are matters that require separate permits and or licenses. All of those, a person doing any of those things essentially without the relevant permit or license under the act or the regulations they're under is committing an offence, and is doing something that will leave them open to civil remedies as well. I suppose not the most important thing, but one of the most striking things from an individual's point of view, or from maybe an NGO point of view, or a private party's point of view in the Waste Management Act, is the mechanism set out in section 57 and 58 of the 1996 Act. Essentially what that allows a person to do is where waste is being disposed of or stored and is causing, quote unquote, environmental pollution, a person can go into court and seek an order of the court preventing that and seeking it to be remedied. Now, what's the difference between section 57 and 58? There's a long-winded explanation to that, but I can make it short. Essentially, section 57 allows you to go into the High Court to complain about environmental pollution caused by waste management or storage that has already happened or you might anticipate will happen. Section 58 allows you to go to the district court, the circuit court, or the High Court, depending on the seriousness of the damage, and to complain about environmental pollution that has happened. So that's the difference. And obviously there are very serious cost implications in terms of which court you choose. So obviously if you had section 58 available to you, you would most likely be using that. Litter Pollution Act obviously has a role here for ordinary littering, if I can call it that. Fines can be imposed by local authority or guard. That everything from littering to dumping to dog fouling. There's mechanisms under the Act to provide for fines there. Illegal dumping, obviously that's a breach of something that's dealt with under the Act and can be complained about. There's a National Environment Complaints line, which you'll find on the EPA website. Your local authority will take a complaint and the Gardaí will take a complaint about that anyway, although they might direct you from one to the other. It's interesting to note that the onus of proof in illegal dumping cases is slightly different to what you would usually meet in civil cases. So where essentially material within what is dumped gives rise to an apprehension that it is the property of a particular person, that will be the case until the contrary is demonstrated. So there's I'm looking to call it reverse onus of proof. It's not quite that, but it is approaching that. And so I think illegal dumpers often think that, well, you know, that no one saw me dump it and therefore I'm home and hosed, but they're not. You know, if there's material in there that demonstrates that they are in fact the owner of it, it's up to them to put up something to suggest that that's, which isn't always easy. So the last thing I'll say, maybe to sum up all of that, is that your first avenue, so now that we've kind of had a whistle-top tour of the obligations, your first avenue is complaint to the relevant authority. I think that should always be the way, because, you know, the investigations into this type of thing, the prosecution of complaints into this type of thing takes comprehensive resources and a lot of time, and not everyone will have that on their hands or at their disposal. So the complaint to the relevant authority is the first thing. A relevant authority can bring a prosecution in a lot of the breaches that I've just talked about. They are obligations that are punishable are pursuable in the criminal law, but certainly where there a notice issues and there's non-compliance with that, that is almost always a matter for the criminal law. As I've set out, there are circumstances in which you can seek the intervention of the court, i.e. an injunction. Again, local authorities can do that, and it is preferable in most circumstances that the relevant authority will be the one to do that. But there are circumstances in which one can do it oneself. There is also, you should be aware, where obligations are placed on local authorities or relevant authorities, the EPA or Irish Water or whoever else, particularly where those obligations are placed on them by European law, they have an obligation to comply with them. And those obligations can be enforced, and they are enforced, you know, from time to time via court action. Now that's a big call and a complicated question, and you know, you wouldn't be running straight to the High Court, but where a local authority is failing in its obligations, particularly European law obligations, that is a matter that can be enforced by the High Court. And there's the link then for the EPA making an environmental complaint, which I think is probably the easiest. Your own local authority will have a page like this, but the EPA has a national one, and it kind of directs you in terms of where you should be going with your particular complaint. And I think it's quite a useful website actually, but that page is in particular useful. So thanks very much. I think there's a facility for questions. I'm just going to stop sharing my screen now. I think there's a facility for questions at the end.
Thanks so much for that, Michael. That was so comprehensive. And would you mind maybe sharing that link that you had in your last slide just in the chat box, if that's possible?
I will do, yeah.
No rush, just if you have access to it. Thanks so much for that. We're going to hand over to Phoebe now.
Right. Thanks, Clodagh, and thanks, Michael. Gonna sort of turn to the planning side of things now, which is another kind of one of the formal mechanisms that Clodagh mentioned, and is key in environmental decision making at the local level, since development of all types and scales can have such tangible and significant impacts on the environment, both positive and negative. And planning is also a key area where some of the main environmental laws are applied. So I want to give you a rundown of how you can engage in the planning system, primarily through making submissions. And often this is portrayed kind of as people objecting to development and cast in, a fairly negative light. And, NIMBYism does exist, but I think planning submissions don't have to be just about objecting. It's about ensuring high standards of environmental assessment, environmental protection, and also creating vibrant and sustainable communities that we want to live in. So a huge part of my job is analyzing and making submissions on planning applications and looking at the associated environmental issues, but you absolutely do not have to work in planning. You don't have to work in an environmental job, a legal job, anything like that to make effective planning submissions. Anyone can do it. And there are sort of any number of approaches you can take to that. And I'm going to talk a little bit about how to do it, starting at the most local level. So local authorities, city and county councils, walk you through finding a planning application file, the relevant documents you might want to look at, go through what you can include in a submission and how to actually get it submitted and get it validated, and also cover submissions to An Bord Pleanála and county development plans as well. But starting at the local authority level, so councils, majority of planning applications in the country are made to county and city councils. There's on average about 30,000 a year. Some of the larger ones go directly to An Bord Pleanála, but we'll come back to that in a bit. So how do you find out about open applications? What's being looked at the moment? What can you comment on? Each application is required. If you're applying for planning permission, you have to put up a site notice, at the actual site, which gives information about what you're applying for, who you are, the address, all of that. So you can actually physically see those. But if you're not, wandering around your local area, you can also look online, because the councils have to publish lists of new applications, decided applications, etc. And those are available on their websites. Quick Google search will find that for you. And sometimes the bigger applications, big industrial stuff like that, it often makes it into the news as well. So you can view planning application files in hard copy at your council office, but now they're also required to be uploaded to each planning authority's online database. And now, as a result of COVID, they are required to be uploaded within 5 days of being submitted to the council. And I'm going to share my screen here and kind of just show you around how this all works. So there's this very handy e-planning website that's kind of your one-stop shop for finding these council databases. And you can see, you can click on whatever county you're interested in. Just be aware, if the city council, like say Cork City or Galway City, is separate, you have to click separately. And also Dublin has a little pop out. So we're just going to take a look quickly at an example in Fingal. And here you have the search page. So how to find a specific application. There's various ways you can do that. Each application is given a unique reference number. They're usually numerical. So if you know that, you can search for it. You can also search by description. So, that could be anything from a data center to a house. So you can search that way. That description will be on the site notice. So that's one way you can find it. The address, either specific address, townland if it's in a more rural area. The applicant's name is another one. So I'm going to show you an example of a data center because it's a big application. Also definite environmental impact. So I'll just kind of show you around that. This is your search results page. Sometimes there'll be more than one, so you kind of have to filter through sometimes, but that's okay. Click into that. And here you have your application details. So there's that reference number that I was talking about. Each application will have one. Here's the description of the development. Sometimes these are super short and they just say dwelling house, you know, that kind of thing. Bigger applications can be really long and kind of hard to parse. It's not immediately obvious it's a data center. There it is. So sometimes you kind of have to dig through it a bit to figure out what's actually being applied for. There's the location here, the applicant's name. And if you come down here, you can see the status. So things that you might want to look for, if it says new application, it might be open for submissions, since submissions are accepted for 5 weeks from the day the application's lodged. If it says further information, you may also have an opportunity to comment, because sometimes the planning department won't feel they have enough information to make a decision based on the initial application documentation. So they'll request that the applicant send them additional information. And if the planning department deems that to be significant, it's reopened for a further 2 weeks of consultation. If there's an environmental impact assessment involved, it's a bit longer. So you can comment again at that stage. It might also say granted or refused, or under appeal, as in this case, which means a decision has been made or a decision has been made and it's been appealed. If it says invalid or withdrawn, it means the application is no longer being considered and you don't need to make a submission. Another thing to look out for is the application date. So that was the date it was submitted, and submissions will be taken 5 weeks from that date. Luckily, they also very handily put the date that you can submit, or the deadline date for your submissions. This one's a bit confusing since obviously that's significantly more than 5 weeks after the 24th of August, but that was because this one did go to further information. But yeah, keep an eye on this date because that's your deadline day. So going to take a look at where they keep all the documents. So here, this is where you'll find everything relating to the application. And sometimes there's just a few, sometimes like this one, in the case of a big development like a data center, there's tons. And it's the labeling of the files can be quite different depending on just which council, which file. Sometimes it's really easy to look at, sometimes it's not. Obviously, this, you can see here, they're all labeled the same thing. And sometimes you just have to click in and see what the individual files are. But just a couple of things to look for that I would start with is the maps. Where is the development? What are you actually looking at? Where's the site? And they usually have maps at different scales, as you can see here. The red line delineates where the actual development is proposed. You can also look at the site layout, so where specific buildings are going to be. Plans, elevations, and sections are usually the drawings of what's actually being built, so you can get a sense of what it is. You can also take a look at sometimes, and it depends on when they upload them, but the reports from prescribed bodies like ourselves, also reports from internal council departments like Environment Department, Heritage Department, as well as submissions from third parties. And sometimes councils don't upload those until after the 5 weeks end, but they can be useful kind of to look through and see what potential issues are, things like that. Since we're talking about environmental stuff, bigger planning applications sometimes will have environmental impact assessments. Not all applications have them, but generally big industrial proposals, big energy proposals, certainly data centers will have them. And again, the labeling of the files can be a bit spotty. These just say environmental impact statement. They're huge documents. They assess the potential environmental impacts across a number of categories. So I generally start and click through and look for something that looks like this. Non-technical summary. It's a really good place to start. You don't have to, you don't have to dive into the EIAs at all. But if you're looking for environmental information, it is useful. And sometimes you do just have to click through and you have to go through a lot of appendices until you find something that looks like this. But once you get it, the table of contents is your friend. It's the best place to start. You can look through, and sometimes they do silly things like this where there's one file and then it continues in another file. It can be very well laid out or not, it just depends. But what I would start with is the non-technical summary. It'll give you a good general overview of the development and what they've assessed to be the potential environmental impacts. And just since we're looking at a data center, something I would immediately look for with that is the climate impact, because it uses a lot of energy. There's going to be an emissions impact. So I would start looking for the climate section. You can see how much information are in these documents. And there it is. So I would say, okay, well, looking for the climate impact while it's operating. So that's the operational phase. So potential impacts of the proposed development operational phase. And that will tell me what they're predicting the emissions associated with the power consumption to be, and their assessment of what kind of impact that's going to have. So that's just one example. You know, there's water, there's biodiversity, there's human health, there's all sorts of things. I would recommend, if you're interested in this sort of thing, just look at a few and you'll get your head around it pretty quickly. A thing that I find quite useful actually is if there's an environmental impact assessment or a file called planning statement, planning report, there's often a section in there called description of development. And those, particularly for big proposals, they can really help you just get your head around what's actually being proposed, because, you know, sometimes the development descriptions are just not particularly clear. So I use those a lot just to kind of get a sense of the site, what they're proposing, and just wrap my head around the proposal. Other things that might be included in an application that you might want to look at are ecological assessments, hydrological assessments. And again, you don't have to look at these, but if you're interested in seeing what they've said about environmental impacts, those are good places to start. Just a couple of tips and tricks. Sometimes councils will upload word searchable PDFs, which is great. You can search them if you're particularly interested in impacts on birds. You can use the word search function. Other times they don't upload word searchable ones, but if it's there, I would use it. Yeah, and I would just really explore, click around in the documents, see what's there, familiarize yourself. This is there's 10 pages worth of documents. It's a lot. It's one of the bigger ones. It's kind of, won't get much more overwhelming than that. Sometimes it's really easy. I'm just going to show you another example really quick, because the 4 Dublin local authorities all kind of look like this. The rest of the country uses, for the most part, a slightly different system. It looks different, but it's the same function. So here, again, your search types. I'm going to search by reference number. Just look at another data center. Again, very similar. And, you know, here's the status of the application. If submissions are open, that's your key date there. To find the files on this system, this is ePlanning. They're all under ViewScan files. And here's an example of one that's actually pretty well labeled, so you can see what's in there. You know, environmental impact assessment volume 1. That's kind of what you want if you're looking at an EIAR, so that's easy to find. Something to know about this system that took me a while to figure out myself. If you see number of files here and it's more than 1, they're kind of hidden and it can be a bit confusing. And also here's an example of one that's not a word searchable PDF. You can click through here, but if it says more than 1 file, you got to go up here and there will be additional documents there. And that can be very confusing. Yeah, if you don't know what you're looking for. So that's kind of very brief tour of the planning websites. So when you're actually making a submission, there's so many options about how to do that. They can be very brief, they can be very long, they can be extremely technical, they can be not technical at all. It's really up to you. So things you can include, basically it has to be planning related. So this can be basically your thoughts on the development's compliance with policy. So that can be very, very local, say a local area plan or a development plan, how you think the proposal complies with the policies in those. It can also be national policy, could be regional policy, that could be on transport, climate, you name it, or also EU law, because these development has to demonstrate compliance kind of all the way up, local, all the way to EU. So you can comment on that. You can comment on the assessments provided by the applicant. So, say you're interested in water quality issues and water pollution, and you want to take a deep dive into an environmental impact assessment or, a hydrology report. Do you think that those assessments cover all of the potential issues? Are there any that you think they left out? You can also include your observations based on your knowledge of the local area. And I think that's a really important one. So say that there's a big industrial development planned in your area and there's a river nearby and you walk along it every day and that you regularly see otters or signs of otters. Say that, include that in your submission. Or if it's a large housing development and that it's kind of on the edge of town and there's not good public transport access to services in the area, you can say that as well. So your knowledge of your area is really important. And I think it's a really good thing to include. And, you don't have to go into all these super technical assessments. You can just really apply what from your area. A key thing is that it does have to be about planning issues. You say don't include anything personal grievances, anything defamatory. That's not stuff that can be included. And do bear in mind that the submissions are made public. So when you're writing them, it's good to keep that in mind. And like I said earlier, they can certainly be objections, but they don't have to be. They can, one of the key things that you can do is ask for more information. And we do this all the time. If you feel that there's something that hasn't been adequately assessed, like cumulative impacts with another proposal in the area, maybe you've seen bats or birds and you think that a survey is needed, ask for that. Say that you think additional information is needed to make a decision. You can also support applications. And if you think something's going to have a positive environmental impact, you can absolutely say that. So when you actually come to submitting it, things you need: your full name, your postal address, the reference number, so that numerical reference number that I showed you, your observations, so whatever they happen to be. There is a €20 fee. You can pay that various ways. Councils will have information on that online. And make sure that it's made within the 5 weeks of the application being lodged, so pay attention to those deadlines. You can also make submissions as a group. So this can be an official group like a resident association, NGO, or just if you're a bunch of people who want to make a submission. This is really useful in terms of sharing the costs as well. So just bear in mind, if you are submitting as a group, have one name and one address that's submitting on behalf of the group. You can submit online, you can submit in hard copy, dropping it off, or by post. You can pay in various ways as well. And all of that will be online. Information on that will be online on each council's website. I'll just show you a quick example of a submission that we make. There's the reference number, the applicant name, the description. There's our address. Then there's the submission itself. And finally, my name, signing it off. So, you can format it any way you like. That's just one example. Moving on just quickly to Onboard Planola. So if you make a submission on an application at council level, and then you disagree with the decision that the council makes, you can appeal that decision to Onboard Planola and they will reassess the application. And in terms of what to include in an appeal, it's actually fairly similar to the planning submissions, that you would make on the original application. Just go into detail about why you think the decision was incorrect. Basically lay out the grounds of your appeal, and again, only include planning issues. Do you think the council assessed environmental impacts well enough? Do you think something should have been considered that wasn't, et cetera, et cetera. Some people do hire planning consultants to do this, but that's very expensive. So that's not an option that's open to everyone. And to make an appeal, you need, again, your full name, your address, the reference number and description of the application that you're appealing, your grounds of appeal. Crucially, you need a copy of the council's acknowledgement of your original submission, which they will issue you every time you make a planning submission. You will get, a piece of paper that is acknowledging that you submitted a valid submission. So you need to put in a copy of that with your appeal. It is very expensive to take an appeal. It's 220 euros in most cases. There are some exceptions to that, and that's detailed on Bord Plenalá's website. But yeah, again, you can make appeals as a group, so that can help very much with costs. Bord Plenalá has a form that you can fill out to take the appeal, or you can send it in kind of as in the same format as a planning submission. And they need to be made within 4 weeks of the council's decision. Crucially, they need to be in Bord Plenalá's hands by 5:30 p.m. on the deadline day. So appeals cannot be made online. They have to be posted or hand delivered to Bord Plenalá's office, which is off O'Connell Street in Dublin. So just be very aware that they do not accept anything late. And just to show you here, this is an example of an appeal on their website. Here is where you'll find all the documents. It'll be on the county council website because they don't store appeal documentation themselves. There's the date it was lodged, etc. So you can also observe on appeals, which is basically the same as the type of submission that you would do on an application to a local authority. The same criteria would apply on what to include. The deadline for those is 4 weeks from the day the appeal was lodged. They do have an online submission system for observations, which is great. You can go click here. It'll take you through it, and you can pay online, which is also great. Just a quick thing that I find really helpful is they have a calendar. And if you say you're taking an appeal and you know the council decision was made on 1st of June, this tells you the last day to make an appeal. Same thing applies for observations, because the deadline for observations is also 4 weeks after the date the appeal is lodged. So you can just click and it'll tell you that. I just find that really, really helpful. There's 2 other types of applications that can go to Bord Plenalá that I just want to touch on. That strategic infrastructure development, so very large infrastructure, energy projects, motorways, rail lines, stuff like that. And strategic housing, which is big housing developments over 100 units. Now that system is moving away from Bord Plenalá back to council level. So you'll be able to make submissions on large housing developments back with the councils shortly, but there are still a few of the strategic housing ones going through Bord Plenalá. You can observe on all of these types of applications. They're open for comment for at least 6 weeks. Again, there's an online submission facility available. There are also lists. You can find out what's been lodged. There's new strategic infrastructure cases. They are required to publish site notices as well if you're looking to find what's open at the moment. And again, observe on these just as you would a standard planning application to a local authority. Same criteria apply. The fee is €50, but again, you can observe as a group. There is no facility for appeal of either strategic infrastructure or strategic housing. The only option to challenge a decision is judicial review, which I'll touch on in a second. But the fact that the strategic housing system is moving away from Bord Plenalá back to the councils means that there will be an appeal facility available again. In terms of judicial review, very limited circumstances you can challenge a board planalis decisions on appeals, strategic infrastructure, strategic housing. That only looks at the legal validity or the lawfulness of the decision. It doesn't reassess the planning merits. So it's not a planning appeal round 2, basically. They're very expensive, and the bar to get leave from the court to even take the case is very high. I won't go into detail here, but my recommendation is always to seek legal advice. If you think you want to go that route, that's the best way to go. You have 8 weeks from the date of a board planalis decision to do that. So that's kind of the whistle-stop tour of the planning system. I'll just very, very briefly talk about development plans, because they are the sort of more policy side of planning at a local level. They guide development in your county and set out the policies against which planning applications are assessed. There's 3 main opportunities where you can have your say in that. There's the pre-draft stage, where the county or the city is reviewing their current plan, which are made every 6 years. And they put out kind of a document outlining their headline issues for the next plan. So you can comment on that. You can also comment on the draft plan, where they actually lay out the policies, the objectives, the zoning maps. You can comment on that as well when that's released, as well as the material alterations, which are put out. It's any changes they make on foot of the original consultations. They're widely publicized when they're out for consultation. They're online, they're published, in newspapers, etc. When most councils now have online ways to make comments, they're very easy to find on the council websites. They also accept hard copies and sometimes email as well. Again, your submissions can be as extensive or as brief as you like. They can cover the whole plan, they can cover a single policy, and you also don't have to live in the plan area to make a comment. So if you want to talk about climate issues in another county, that's absolutely a legitimate thing to do. Just to call out that the Office of the Planning Regulator has this very useful website showing what's open for public consultation at the moment and what's coming up. And I'll put the link to this in the chat, but it just can help you keep track of what development plans are kind of, open for consultation. Just going to drop some of the resources on all of this for you in the chat. And yeah, so yeah, very whirlwind tour, but I hope that gave you some tips and tricks for navigating the planning system and how you can engage in it. And really the key message is that anyone can and should engage in the planning process and all the environmental decision-making that goes on in it. It is your right to engage in it. And I think it's because it's so key to shaping our communities, protecting our environment, we should all be exercising that right. So thanks very much. And I'll turn that back over to you, Clodagh.
Thanks so much. That was really practical information, so really appreciate that. There's some questions that have come in. We're nearly up on time, but just to note that we can't really advise on a specific situation, but Community Law and Mediation do provide free legal advice clinics on environmental issues every month. If you'd like to book in, do just send us an email. I'll pop our email address into the chat box now. One question that has come in is on the issue of whether there is publicly accessible information about the type of energy that a data center would use and what data it would be used for. Would either Michael or Phoebe have insights into that?
Yeah, so generally in the planning application, in terms of the energy use, they will discuss that. Generally, they'll have to say things like if they're getting a grid connection, it will go through all that. They'll detail the amounts of energy they're predicting to use. It's not always very specific. If it is just a grid connection, tapping into the existing energy supply, there's not a ton of information beyond that, but all of the details will be in the planning application. In terms of the data that's actually being stored, from the planning side, they don't really go into that. Sometimes there'll be for specific companies like Amazon, Google, Facebook, etc., and that will be data specifically for those companies. Other times they're larger companies that host data for numerous small companies. There may be information about that available elsewhere, but you would not find that, you would not find great detail on that in the planning application. But again, I would take a look at, in the planning application, the non-technical summary of the environmental impact assessment and the planning report would be a good place to start, particularly on the energy side of things.
Great, thanks, Phoebe. Is there anything you'd like to comment on that, Michael? I think you're just on mute there, sorry.
How about now?
Yeah, I think we can hear you now.
Yeah, I was simply saying no. That's it. The energy use will be part of it, and that's something that can be interrogated. But what data is there? No, I'm trying to think of a way that one could approach that by tying it to something relevant to a planning objection. But I'm kind of struggling to. But maybe people who know more about data and all of that stuff might actually come up with an inventive way of tying it to an objectable ground. But I can't think of it.
That's great. Well, thanks so much to both of our speakers for providing such excellent insights today and for keeping to time as well. We really appreciate it. And thanks to everyone for tuning in. This webinar is being recorded, so this will be available afterwards. Please do share it with your networks, and please keep an eye on Community Law Mediation social media for future upcoming events. We are going to be sending around a survey afterwards to ask you your opinion of how we ran this webinar and how we can deliver more interesting webinars like this in future. And yeah, just to say thanks again. And if anyone is interested in, if you are experiencing environmental issues like the ones we discussed today, or if you know someone who is and who might benefit from availing of our free legal advice clinic, just send us an email to info@communitylawmediation.ie. Thanks, everyone.